Добрый день. I guess it is working. This is going to be the 15-minute version of a conversation that normally takes 3 hours. So I'm going to crunch it down, and we're just going to go for it. The topic being discussed is how you can issue your ICO tokens into the American market, i.e. into the American investor market, without running afoul of the United States securities laws. So I'm going to do a quick poll. Who's completed an ICO anywhere at all? Raise your arm. Congratulations. Who's thinking about doing an ICO? Who really wants some ICO money? I know you do. And who is nervous about the legal system in the United States? You should be raising your arm. Okay. So I'm going to show you how to maneuver through the situation. And again, this is the 15-minute version of, okay, here's a disclaimer. I'm a lawyer. I'm not your lawyer. That's that? Okay. Let me kind of set this up a little bit. So imagine you have a cutting-edge Ukrainian startup called Gambit. And in English, Gambit means a bold move at the initiation of something. And they're doing something related to crypto and blockchain. Not really sure, but there's going to be a white paper coming out soon. You can all read it. And in order to accomplish their goals, they need to raise at least $20 million. It's not just to come out with their product, but it's to be the first mover in their market before a competitor comes out with a similar product. Now, who here thinks you have an idea that no one else in the world has thought of yet? Exactly. You? All right, I want to talk to you after. And of course, they're going to do this via an ICO. Now, kind of the headline is that international companies or startups engaging in token sales in connection with an ICO have been avoiding the United States because they're scared of the law there. I would argue with the ICO market becoming more competitive and with China banning ICOs, it's time to take a fresh look, especially if the return is significant. If you get an extra $20 million or an extra $10 million by dealing with the complexity of the US market, it can be worth it. Okay, and let's go to the next one here. And just kind of nail this down a little bit. US still, for now, at least has the world's biggest economy. It has the deepest capital markets. It has investors who want to invest in ICOs. And obviously, startups want to access this capital. The detail of why their startups are nervous about it is that the securities laws are perceived as complex and burdensome, and also the main agency in the United States that's responsible for enforcing those laws, which is the US Securities and Exchange Commission, or the SEC. It's not SEC, by the way, everyone says SEC. The SEC is perceived as being very tough and very ICO unfriendly. I have to say that's actually not true. So there's 4 routes that startups seem to be going when they contemplate accessing US capital with an ICO. The one I see quite often, I guess, is option number 1, which is, and by the way, I'll send everyone this PowerPoint slide, just email me and I'm happy to do it. There's 4 ways you can go with this. The first route is, we're in Ukraine, we're in Israel, we're in Nigeria, we don't care. We're going to sell our tokens everywhere, collect the money, become very wealthy, move to Ibiza, and then the SEC can talk to our lawyers. That is an option. I wouldn't recommend it. What can happen if you go that route is, yes, you can be successful, but the SEC can tag you as what's called a bad actor and then prevent you in the future from accessing US capital. Option number 2, and I'm seeing this a lot, is that startups that are doing ICOs just don't sell into the United States. You come to their website with a US IP, they say, sorry, not for you. You VPN it into Germany and then try again, and you can buy their tokens. So yes, that is a route many companies are going. Again, with China offline and more companies doing ICOs and the market becoming more competitive, I think avoiding US investment can be a mistake, especially if you're leaving money on the table that your competitor can come and grab it coming in after you. So I'm not saying go to the US market, but I'm saying it's worth consideration. Option number 3 is what I'm seeing a lot of also, which is companies, startups, very carefully design their tokens so they're utility or protocol and not asset tokens, and they swear up and down it's a utility token. It can't possibly be subject to American law, and that's a good theory, and it's not completely wrong, but it's complex for reasons I'll explain. Also, just because the rules are a certain way now, that doesn't mean the rules are going to stay that way. So if you issue something that's not a security now and you don't qualify it, and then the SEC changes its mind, you can potentially have an issue. Also, and this is a little bit more subtle, I see a lot of startups taking their tokens and stripping out the potentially useful investment characteristics of that token, i.e. the fact that it's paying dividends or giving people a vote or giving them a commission, in order to force it into being a utility token. Well, that may be a suboptimal design. You may want your token to have investment characteristics and to be a security in order for that token to provide the biggest benefit to your company and the people using it. So the fourth route, which I'm saying consider, is if you have a company, your startup, and you're issuing tokens via ICO, consider selling into the US market and understand that the default rules are tough, but there's many exceptions that are relatively easy to make use of to those default rules. So just imagine our company Gambit decided to sell into the US. They did not want to modify their token to make it just a utility token. They wanted it to be an investment or security also. And as a result of doing that, they reached their funding goal. And because they found a proper exemption to the default rules, it wasn't that tough for them. So I'm going to sort of dig into this. If there's one thing I want you to take away from today, it's that the foundation of all securities law in the United States, the floor that you can put every other concept on top of, is the Securities Act of 1933. Okay, this is the basis for the whole structure in the United States. Every other law came after this and is based on it. This law was enacted by the US, obviously in 33. This was following the stock market crash of 29, which was caused by rampant speculation in stocks and bonds. People were selling stock, not providing any information about it. People were buying that stock in droves, just hoping that they could sell later to someone else. Sound familiar? What the 33 Act did is they said anytime you're selling a security, a stock, a bond, or anything like a stock or bond in the United States, the default rule is that you need to register, and that's a term that's used often, you need to register that security with the Security and Exchange Commission. That's the default rule. Okay? And that default rule is tough. It's tough for a couple reasons. It's because the act of registering your security, number one, means that you have to create a document called a prospectus. Prospectus is a complex legal document that describes your company, describes the security you're going to sell, and describes the manner in which you're going to sell it. And when you file this prospectus with SEC, they can give you comments, you have to revise it, and finally, after several iterations, after several tries, you can get it right. And also, you have to complete and file various forms with SEC, and those can be complex and expensive. And then if you actually register your stock and you go public, that's what it's called, you have ongoing reporting and compliance requirements. No one at this conference, believe me, wants to do a full registration with SEC. And this is what people are kind of nervous about. Right? It's only really appropriate for a company going public, like Apple or Google or something like that. Okay, but let's note a couple things. Yes, you don't want to do a full registration. The first thing to note is that under the 33 Act, it's only the sale of securities to the public that need to be registered with SEC. If something's not a security, then you don't need to register it. If Starbucks is selling you a double latte they don't need to file a form with the SEC, because a latte is not a security. If you're selling land, or a pencil, or currency, it's not a security. So if it's not a security, you don't need to worry about registration. If it is, you do. That's number one. Note number two is that keep in mind that the role of the SEC is not to make sure an investment is good, or smart, or wise. Its only job is to make sure that investors have enough information available to them to make an informed decision. Not a good decision, but an informed decision. Now, that concept leads to several opportunities, because what the government has decided is that if investors are wealthy enough or well-advised enough, and you're only selling to those investors, you do not need to do a full SEC registration, because there's an exception to the rule. And then another thing to consider is that it is part of the SEC's job to facilitate, to allow, to create a basis for securities transactions in the United States. It's not against everything. It's not against ICOs. It recognizes that these activities, these innovations are important. And at first, it's kind of looking at ICOs and Bitcoin and crypto, sort of like, what the heck is this? You know, terrorist drug dealers, all that stuff. It's evolved its point of view. It is not saying that every ICO is a security, and it's not trying to punish people engaging in these transactions. It's trying to make sure that where appropriate, the law applies as written. Okay, so you all saw the movie The Matrix. Suppose you want to break out of the Matrix. You're Keanu and you want to break out into real life. How do you wake up from the Matrix? How do you wake up from the US securities laws? Well, if it's not a security, then you don't need to worry about it. Okay? But you know, what is a security? Like everything in law, especially US law, the question is, it depends. Or the answer is, it depends. Now, things like stocks or bonds are specifically named in the 33 Act as regulated and covered by that act. Well, is a token a stock or a bond? It may be like a stock or bond, but it's not called a stock or bond. So there's this mystery expression called an investment contract. If it's not a stock and it's not a bond, well, maybe what you're doing is an investment contract. The Act uses that term, but it doesn't define it, just to make life interesting. And the reason it doesn't define it is it recognizes that things change over time. So if something is, you know, far in the future, like in 2017, people come up with this crazy idea of a token. They don't have to rewrite the Act to put in the word token. They just figure out if a token is an investment contract. That's why that's there. So the way you drill in on something new, like a token, and decide whether or not it's a security and falls under the 33 Act, is you apply this famous case. Like I said, the Securities Act of 33 is the basis, statutory basis of all of US securities law. I'd say the foundational case, what a judge decided based on that act, is SEC versus Howey. You're all living in an SEC versus Howey world, even if you don't know the name, and I'll explain why. This is when the Supreme Court of the United States took that investment contract idea and provided some guidance as to what in God's name does that mean. Basically, Howey was engaging some land deals. He was paying commissions. The SEC said, you know, that's a security. You should have registered it with us. Howey said, no, it's not. It's land deals. I'm paying commission, but, you know. Well, he was wrong. It should have been registered. And the US Supreme Court provided some helpful guidance. The question is, where do I need to point this here? Did I point to you? Did that work? You know what? I'm going to go over here. And I know I'm moving fast, but I want to give you guys the headlines here. Okay. This is the Howey test. Okay? Something is an investment contract and is therefore a security and is therefore subject to the Securities Act of 33 if 1, 2, 3, and 4, each one of those are true. Okay? There needs to be an investment. It can't just be you're giving someone something. Okay, into common enterprise. And there's a whole bunch of fighting about what that means. Where you're trying to get a profit, not just because you're a nice person, where other people are generating the results. So if you start up your own law firm and you're making money off of it, it's not a security because you're the one doing the work. Now, like everything else in law, it has all kinds of shades of meaning to it. When people design a utility token, when people say it's not a security, what they're really trying to say is, we think we know what this test means. We've applied this to our token design or our white paper, and it's our point of view that the token we're issuing is not a security. Everyone's applying Howey, even if they don't know it. That's what they're doing. When these fancy token design consultants talk about this, they're trying to apply this. Here's what I would say, and I'm being a little bit sarcastic with this. When people do utility tokens, what they're really saying is, I don't live in the US, I'm trying to figure out what Howey means, I'm trying to apply it to my token, and I'm praying that I'm right. Okay? That's kind of where they're going with it. There's also a question of how much utility is enough. If something's a little bit like an investment, like 1%, but not 51%, is it a security under Howey? This is the framework, though. And this is what I'm talking about when I say the SEC has not been unhelpful. They're actually being a little bit helpful now. So in response to Ethereum and the DAO hack, way later in July 25th of this year, the SEC issued a report on Ethereum and the DAO attack. And they applied the Howey test to the DAO. So if you want to see how they think, if you want to read how they think, read this document. It's worth reading. That is their current point of view about how to look at a token and decide if it's a security. They applied the Howey test, and because the DAO was set up so that token owners were receiving a portion of the profits, of course it was a security. That's kind of a no-brainer. It also addressed the question about whether the SEC was aware of tokens, and obviously the answer is yes, they wrote this, and now they're watching. Like the dragon is awake. And they looked at the way the DAO set itself up, said these tokens are investment contracts, therefore they're securities, therefore they should have been registered with the SEC. What they also found is that Ethereum is not a security. It's a currency. So they're not going crazy with it. They're not over-applying the Howey test. They're applying it line for line. If it meets these 4 elements, it's a security. If it doesn't, it's not. So the takeaway from this is, yes, you can avoid US registration entirely if your token is not a security, but you may not want to. Just be aware of where the law kicks in. So this is where the law kicks in. If your token is an investment contract under Howey. Now, take our sample company. I guess I'm going to race to the end here. Take our sample company. They want to access US capital. They want to move fast. They need to. They want to issue a token that has investment characteristics, that is an investment contract, because it's going to help them do their business. And they want, like I said, they want to sell it in the US. I suggested this is something worth considering if the payoff is large enough. Because they're smart, they realize that the default rule about having to register their security and do all that craziness doesn't apply to them because there's an exemption. And that exemption is based on the fact that they have investors either have enough resources or enough good advice that they don't need to be protected. And again, I'm going to race it to the end. There's 2 broad names of exemptions that you should stick into your minds. There's a Regulation D exemptions, and there's a Regulation A exemptions. What you're going to hear again and again in these conversations is Regulation D. There's 3 exemptions under Regulation D, and they're in different rules. I'm really going to fast forward here.
Really going to have to cut that off. So I'm over time quite a bit.
I'm going to take 10 seconds. Regulation D, 3 rules. The last exception is Rule 506. You can raise unlimited amounts in the US without registering your security. That's the punchline.
Wonderful.
Thank you very much. Thank you.